we'll now turn to questions from the committee. To begin with, I want to explore the importance of legal representation. Representation rates in immigration court have been low for years. According to EOIR data, just 44% of the 5.6 million people who appeared in immigration courts between 2002 and 2022 had an attorney. And currently, out of more than 2 million immigrants with cases pending before the immigration courts, fewer than half have representation. These rates are even lower for immigrants in detention. However, attorneys have a significant impact in every stage of removal proceedings. Individuals with representation are more likely to show up for their court cases and are significantly more likely to be successful in obtaining relief in immigration court. In fact, since 2001, EOIR data shows that only 6% of immigrants who were unrepresented were successful in winning their cases, whereas having representation makes detained individuals more than 10 times more likely to prevail. Question is for Mr. McKinney. Can you just elaborate further on why having an attorney makes such a difference in outcomes for individuals and how having representation impacts court efficiencies generally?
Thank you for the question, Chairman Padilla. As our written testimony indicates, there's a 2016 study from the American Immigration Council that indicates that represented respondents in immigration courts are 5 times more likely to gain relief. TRAC, a nonpartisan organization whose numbers we all rely on, points out that those that applied for asylum affirmatively and then had to defend that asylum application in immigration court, they saw their approval rates go to almost 76% because they were nearly all represented. Now, I do want to point out that that 76% only still represents a very small number of total grants in our system. But the point is that representation ensures due process. But it also makes the system more efficient. When all the parties know the rules and know how to present a case, cases move faster.
Thank you. That's certainly my takeaway. Should not be misinterpreted. The goal here is simply to grant more for the sake of granting more. The point here is true due process and an added benefit of improved efficiency of the court. Now, I do want to go back to Mr. Simpson's testimony. His arguments or recommendations about contempt authority, ability to dismiss, the reference to 12b-6. Judge Sankoff, interested in your response to those statements and recommendations, and Mr. McKinney after that.
The first, I'll take the first one, which was the discussion about dismissal for failure to state a claim, and the statement of 75% of the cases would be removed from the docket. I'm not quite sure where that number, 75%, has come from, but to me that seems like a very large number and a very large percentage that I can't quite imagine how that could happen. But let me explain the concern. Most of the people that appear before us don't have representation. So how a judge would be able to get them in a position so that they could state their claim and then the judge simply decide the case without them having had an adequate opportunity to present their claim, I'm not quite sure how we would be able to do that. Fortunately, the administration has put in place, and we could consider expanding it, opportunities for pretrial conferences, because at those pretrial conferences, the Department of Homeland Security can certainly say, we support this case and it won't require a full and complete hearing. But the vast majority of the cases that I see that appear before me have sufficient documentation within them and the department has security questions they want to ask. I would need to put it at least for a hearing. Thank you.
Mr. McKinney?
I appreciate Mr. Stimson's comments, and reading his written testimony, I found myself agreeing with much of it if immigration court was a real court, but it's not. Most of these respondents are unrepresented. The rules of evidence, Senator Padilla, literally do not apply. The rules of evidence do not apply in immigration court. I had this actually happen to me a couple of years ago on a gender-based claim. The immigration judge dismissed it without hearing testimony. As I indicated in my earlier remarks, I appealed. I won that appeal. That case is still pending. It's been pending now for 6 years. So curtailing a person's right to a full and fair hearing does not speed things up. It slows things down.
Thank you. I'll have further questions in the next round, but at this point, Senator Cornyn.
Mr. McKinney, you say that immigration courts are not real courts.